Test, test. All right. Looks like my audio is working. All right, take 127. Just kidding. Been having some computer stuff issues. So hopefully my image doesn't drop out at any point or we lose sound or anything. Welcome to the summer session. I'm going to be recording probably at least one video per week for this class for the next few weeks as we have class. Maybe sometimes two. I think this week I'll probably do two. If this were a full term, I'd be making a lot more videos, probably just kind of pipe into the classroom or give you the video feed from the classroom itself. I'm still working on getting a book for the class itself. So today, parts 1 and 2 for the course. Basically, I'll put out a PowerPoint that kind of outlines all the things I talk about, but you'll want to watch this, pay attention, because there might be some things that I talk about here that aren't represented in the PowerPoint that could show up on quizzes or exams. Since this is our first video, I should probably talk briefly about the class itself. If you notice on the left-hand side of Blackboard, that's where you'll navigate to everything that's important in the class. Make sure you start out with the Welcome Begin Here page. After you review everything there, go ahead and introduce yourself, because I do want to get to know all of you. And also go into the syllabus and schedule and make sure you fully read that. And I know it's long, but make sure you read that. You want to read that, and I'll know if you didn't. And that's one of those things that people say that, but no, seriously, that there's something there you probably should find. Beyond that, let's get rolling into it. So, part 1, introduction to criminal law. So probably one of the first things I need to talk about is how this course is different from some other courses. So this is Crim Law 1, so this is Crim Law 1 and Crim Law 2. So Crim Law 2, you get into greater detail. Crim Law 1, we're going to focus more on state statutes when we get into some actual statutory laws. That's what criminal law is. It's substantive law. Statutory law is another way to look at it. It differs from procedures. Procedures is how. This is more about, see, I wrote it down here, defines one's rights, elements of crimes, and individual responsibilities. And we'll get into that more here in a little bit. Is there anything else I need to talk about? No. Okay, so another thing to distinguish from is the difference between criminal and civil law. So if you're watching anything in the popular sphere, probably something that's caught your eye in the last few weeks has been the Johnny Depp Amber Heard trial. Basically, both parties are filing suit against each other in civil court. You'll notice that there are significant differences between civil and criminal processes. First one, that's probably the most important, is which party brings a case. In civil court, anyone can sue anyone, any organization can sue any organization. You basically, anyone or anything can be a party to a suit. When you get to the criminal side, only the state is what sues, is what brings a case. Or you could say the federal government, but you're talking about, it's not an individual decision outside of those who have specific roles in, well, in this case, you're talking about a prosecutor. It's a prosecutorial decision. We'll get more discretion here. Rules of evidence are a little bit different between the two. Both have moral condemnation. So, if you're a criminal, people will tend to look down on you just in general. And if you have found yourself in the public eye of civil cases, you may be looked down upon too from a moral standpoint. Just look at everything that's been said about the two parties to that previous civil case I just mentioned. Like you'll find, over the last few years, there have been a number of things that have come out negative about both parties, and that will continue to go forward as we move forward in the next. Hopefully we'll get a result before too, because I'm really curious to see how that goes. But moving forward, there will still be a lot of negative information about that publicity and moral condemnation. The purposes, well, there are a number of goals that the criminal justice system or criminal law itself serve. But basically what you're talking about is punishment, versus civil case is compensation for those who were wrong. When we talk more about the goals, we'll go into more detail because there's starting to be more of an overlap towards compensating those who were wrong. But in this case, when you're talking about who's wronged in criminal law, typically you're talking about, for the purpose of this course, the state. Penalties. And so the biggest difference here is you're talking about incarceration, maybe for one's life for a period of time, maybe death. That's going to be all within the criminal system. Both the civil and the criminal system have penalties that are monetary damages, but again, that's going to be who those monetary damages go to. Criminal, it's going to be typically the state. In civil, it's going to be to the party that was harmed. Talk about rules of evidence. I probably mentioned this really quickly because I remember if I've got it in another slide. Probably the biggest bit of difference in terms of rules and procedures when it comes to the level of certainty a jury must have in order to find someone guilty. In terms of criminal law, everyone knows that's beyond a reasonable doubt. In terms of like percentage, where people draw that line is going to shift considerably. I would say 95% certain. Everything is gone in terms of doubt, except for doubts which would be unreasonable. To kind of explain that, it's like, 3 people have identified me as the person who committed a murder. Okay, so I've got 3 people have identified me. It's not impossible that I've got an unknown twin brother out in the world who committed these murders in the sphere around me. But is that reasonable? No. For civil cases, you're talking about preponderance of evidence and preponderance of the evidence. And what you're talking about there is largely that it's more than likely that based on the weight of the evidence is what you're looking at. So most people put that around 50-51%. All right. Still going, still picking up sound. Excellent. Things I need to talk about here. Criminal law as a punishment. Okay, so this is one of the ways that we use the criminal justice system. I should say one of the purposes this allows for social control. It's the method through which we get people to, be able to work with one another, be able to cohabitate, kind of thing. We have this punishment here as a way to keep people from harming one another. In moving forward in this system, in using criminal law, there are a few goals that we need to talk about. First one is retribution. That's, I put in here that Furman versus Georgia 1972. That's that Supreme Court case that recognized that retribution is a legitimate goal, purpose of criminal law. It's there to exact revenge. Another way to look at this is the old lex talionis, eye for an eye. Everyone's probably heard that phrase, eye for an eye. That is a legitimate purpose, a legitimate goal of criminal law. Second one is incapacitation. Basically, what we're talking about there is that while someone's incarcerated, they are no longer able to commit crimes, at least out in public. To those who are confined in the same space. It's not to say that they'll completely incapacitate, because you still have a significant amount of crime that takes place in corrections, but that's a different course. Here it mentions historical example, removing the hands of thieves. And that still takes place in some places. All right, next one, deterrence. So here it talks a little bit about general and specific deterrence. So what I think about this is, we have laws on the books that there is a potential punishment of say life in prison or death if you go and murder someone. That is on the books as a way to deter the general population from committing that crime. Right? That most people won't commit it because that exists. Specific deterrence refers to an individual. So if someone has been, already involved in the criminal justice system, the sanctions they'll get for repeated crime are going to be, or supposed to be, higher. And because of that, they should, in theory, be less likely to commit future crimes. So that's how that works in theory. If you want to go more heavily in detail into deterrence theory, just let me know. We can talk about it. At large, it's been found in research not to be functional, I guess would be the way to put it. The empirical results don't support it. However, I would be highly surprised with the last 2 to 3 years of crime rates and massive changes in policy that within the next probably 5 to 10 years, we'll probably have a good bit of research that starts to highlight the fact that deterrence theory does work in certain circumstances, and if public policy is quite vocally that we will not enforce the law, that deterrence is no longer there and crime will increase. Rehabilitation is the final goal or purpose, and that's one that's, I won't make a judgment statement on it, but it's been more favorably viewed at different times in society. You can look back to the 60s or 70s where rehabilitation was a major focus of criminal law, the whole criminal justice system. With the way it was implemented, though, and the way that it was measured, it was something that basically led to what has been termed the nothing works era, because what they found is as they were focusing on rehabilitation, measures they had in place weren't reflecting any positive change as a result of it. So for at least a decade or two, it fell heavily out of favor. We've been taking some steps back towards it. Might even say that we've gone too far in some regards that we're starting to turn a blind eye to things, but that's a different discussion. We'll just focus on the goals. Law and morality. All right. So let me say about that. Big division here. Got it. Here's mala in se versus mala prohibitum. Mala in se, Latin, it's bad in itself, evil within itself. Mala prohibita is evil only because it's prohibited. So examples of things that are evil within themselves, you'd say murder, rape, battery, child abuse, arson, thievery, robbery. Now, all of the major crimes that people identify that in some ways you could see that they're universal across all cultures, across all places, that in general, those specific acts are identified as wrongful. If this were a class and had all of you together, what I would ask you is identify a single criminal act that is always criminal. And what you'll also find is that there is no act that has not been viewed as acceptable in the history of mankind. So those are all the full range of human behaviors. We identify some as wrong in and of themselves, with certain exceptions. There's always exceptions, justifications, and we'll get into that later in the semester. Mala prohibita is only because they're prohibited. Basically, here what you're looking at is more like the social side of law. Here it mentions drug and alcohol related crimes, prostitution. Like if you go out to Nevada, Nevada, however you want to pronounce it, you'll see that those things are not prohibited. Certain places, those types of things are prohibited. You can look at the condemnation side of it as to which ones carry more moral weight. Typically you're looking at those things that are evil within themselves. Is there anything else I can say about that? If you guys have any questions, let me know. I'm just going to go through this pretty quickly. All right. So the structure of the United States government is a very important facet of this. Typically, it's a discussion I have in all my classes during the first week because everyone's kind of figuring out what classes they want to get into. You still have students who shift around, and I don't want to get too far ahead of one. We have more time. That being said, everyone should know that there are 3 branches to the United States government. You have the legislative, the judicial, and the executive. usually go into discussion of why and basically start talking about checks and balances in a way to keep the system functional without too much power falling into one branch or one political body. So that's in theory how it should work. Here it talks a little about the judicial branch and United States Constitution was ratified September 17th, 1787. First 10 amendments, Bill of Rights. You should know those. Yeah, if you're taking any law courses, you should be able to identify the substantive rights that are outlined in the Bill of Rights pretty much off the top of your head. If you can't do that, that would be a good challenge for you to have. You know, that you get to the point where you can identify, okay, so the First Amendment is, you know, freedom of speech, assembly, press, petition, religion. Second Amendment, everyone knows that's the right to bear arms, also form militias is how I would look at that. And right to the Third Amendment is no soldiers shall be quartered. The fourth one is search and seizure, was a probable cause, a number of things. You should be able to do that throughout all 10. Here's where it talks a little about separation of powers and checks and balances. You know, when it comes to framing the entire government, probably the most overlooked and one of the it's highlighted how much thought went into developing the system, but in terms of what it does when it's functioning properly is really quite amazing. I mean, take for example the legislative branch, where it's got its two houses of Congress, the House of Representatives and Senate. You know, what that does is something that most people need to really appreciate, because what it does is, you know, you identify that states are their own sovereign body, right? So they need to act independently to some degree. But in the Congress, what you have is one part is based off of population, right? So the number of seats that a state has is based off its population. The others, every state has two. And basically what you're talking about is the balancing of one of the great debates in terms of, you know, what's popular versus, you know, the needs of the many versus the needs of the few. This is a discussion I commonly bring up in my in-person classes. You want to balance out those things so that you know, the states with many people have their way, but also the states with fewer people have their way too, because, well, you want those things to be in balance. If they're not in balance, what you end up with is a position where you look at a strict democracy and those are not favorably viewed by most, where simple majority completely overrules minorities, any minority, and that's not good no matter how you look at it, whether you're talking people, politics, or anything. It's like you need to have that balance there. Okay, United States court system, it's a dual court system. Basically what that means is states and federal court systems run separately. Where that probably comes up to the most importance is the fact that you know, because it's a dual system, you can commit the same criminal act. If it violates both state and federal laws, you can find yourself being charged at both levels, and it wouldn't technically fall under double jeopardy. Here it outlines the basic systems. You have here it mentions U.S. magistrates. Basically, you're talking about limited judicial role. District courts, circuit courts. So district courts, circuit courts would be, you know, first level appeal, and then you have the United States Supreme Court. That's the top. Everyone knows SCOTUS. Within the state, you'll sometimes have courts of limited jurisdiction. So those are like, you know, traffic courts, drug courts, those types of courts that only focus on a specific thing. You have general trial courts, from their intermediate courts or appellate courts from their state Supreme Court, which is the highest appellate court in a state. So mention. That's some material to take a look real quick. Yeah. Ooh, I should also talk a little bit about that judicial review. So we'll talk about that first. So you have a trial. The results can be appealed. One of the things that your appellate courts can do is something called judicial review, which is basically where they go back and they look at lower courts' decisions and review them along with the statutes and anything that might apply to it. That is an important facet of it, because basically what you're talking about, appeals are reviews for they could be based on certain decisions that were made, whether it's certain evidence that comes in, whether the laws were followed in certain instances. That is important to keep in mind, because basically what you're looking at is a tiered system. What's it? That I wanted to talk about. Maybe I got notes all over the place. Ooh. Yeah, no, I don't think there's anything I need to mention with that. There is something I need to mention related to sources of law, but I think that's one of the next few slides. And I'm just going through the slides as I'm talking. The PowerPoint's available, so you can have that to supplement this video. Next thing we should talk about is jurisdiction. So whenever I mentioned basically your limited jurisdiction, courts of limited jurisdiction, those would be the original jurisdiction for those specific types of things. Typically, you're talking about district courts for federal law or general trial courts for state, and that would be the one that actually tries the case. If you have something that, some instances you might have concurrent jurisdiction where more than one court has the power to try a case. Appellate, we already talked about that. So basically you're talking about reviews. Also a name change. So whenever you move into appellate court, you're no longer talking about prosecution and defendants. You're talking about appellants and appellees. Okay, sources of criminal law. So the big thing that we'll be talking about, one of the major facets of this course will be, in our book, we'll talk about statutory laws. So basically what you're talking about here are the criminal code. Which is where I got a little about substantive or procedural law. When we get into it, what it's going to do is it's going to outline the elements of each and every crime that's there. The next section will talk about elements of crime. So we'll break out what those general types of elements are and what they mean, because it's something that is incredibly important. It's I don't want to get into that just yet. No, I'll wait. So basically, it's what you have to look at to determine whether or not a crime has actually taken place. What types of things are these built off of? Of course, you have constitutions, each state, and of course the United States Constitution, because it'll outline what someone's rights are and source. Case law. So this is where lawyers are particularly important. If you ever find yourself going to court, lawyers should be familiar with what the relevant case law is on a particular subject. So that's case law is the term for basically the history of decisions related to a particular matter. You've probably heard the term stare decisis. If you haven't, it would be good to be familiar with that term. Basically, what that means is the court stands on its previous decisions. So if you're talking about federal courts, we start looking at is Supreme Court decisions. As those are made, they affect everything, every court in the land, essentially, whether you're talking federal system or if it's something that applies to state, it'll affect everything. If you're talking about within a state, as cases are decided, we'll say would be a good example. I'll think of an example in a second. So, but as cases are decided, the history of those cases, how those cases were decided, is going to influence future cases. whenever you start talking about, like if you take procedures, I focus heavily on Supreme Court cases and talk about how things work. Basically what you're talking about there is something either falls in line with previous case decisions, previous case law, or it's distinguished in some way. There's some facet of that particular case that separates it out from the previous decisions. If not, what you'll have is a situation where courts can overrule previous decisions, but that's less common. That's not common. Only if something was incorrectly decided at a previous time, what would that be the situation? Administrative law talks about here, basically rules and regulations for administrative agencies. That's he mentions Congress and state legislatures with delegated power. That type of bureaucratic power is particularly dangerous because we as citizens of society don't have much authority in who are in those positions. Probably the one of the more interesting discussions I've had with students on this particular topic is take, for example, the ATF. Now you can have positive views or negative views. That doesn't matter. But what matters for this conversation is an example. I have theoretically, I have a pistol that's a rifle caliber, meets all the definitions, all the parameters of a rifle or of a pistol, right? But it's designed like a rifle. Take your standard AR-15, M4 platform, right? You have a long barrel, a magazine pistol grip, but it's a short barrel, only within a certain length. I can shoot it from one hand. It's not designed to be shot from the shoulder. Okay, I take that pistol because it fits the parameters of a pistol. I put a brace on it that I'm going to wrap around my arm, right? Stabilized. Something that was literally designed 10 years ago for a guy who lost his arm and still liked to shoot. Okay, still a pistol. I want to say it was roughly 2012 to 2014, something like that. 2015, maybe it was 2014 to 2016. ATF had determined that putting that on your pistol does not make it a short barrel rifle. Short barrel rifles are illegal unless you have a tax stamp and you have proper approval for it. Basically, you go through a process, you pay more money. But it's perfectly fine to have it in that configuration. Well, on one day, it's perfectly legal to have it on there to use it however you like. The following day, the head of the ATF made a determination that he was going to, and he put out letters stating that if you take your pistol and it touches your shoulder while you're shooting it, you have manufactured a short barrel rifle. At that point in time, you take your perfectly legal weapon, it touches your shoulder, you have now violated federal law. You're a federal felon, which when we talk about divisions of crime, misdemeanor versus felony can, more serious in nature, carries stiffer penalties, those types of things. One of the most common division in criminal laws, felony versus misdemeanor. Okay, so touching it to your shoulder, something so mundane that you could do it accidentally, makes you a felon. You can go face very severe penalties. Okay, just literally from one day, one person makes a decision, the next day, you take something you have the legal right to have, even according to them at the time, touched your shoulder, you would become a felon. Okay? A couple of years later, that head of the ATF was replaced and basically issued a new letter stating, well, we're no longer going to consider that manufacturing a short barrel rifle. So literally whomever was in that position, on their own opinion, without any basis on anything whatsoever, could make a decision, would massively influence people on how they can use their own legally owned property. It's like, and that's just one agency and one person in that one position. It's like the amount of power in that is unbelievable. All right, speaking of discretion. So basically be mindful of where we're at in terms of the overall criminal justice system. Okay, so you start out with policing on one end, move to corrections on the other. You start out policing, they become aware of a crime, they decide to investigate, search, eventually arrest somebody. Then they'll go up to the prosecutor in their area, and in working with the prosecutor will make that decision whether or not to file charges. Mentions here seek indictment. That's more of a procedural discussion, because depending on what system you're talking about, those processes work a little bit different. But we'll just say file charges. That's prosecutor's decision alone. So you could have a situation where a person had been aggrieved most seriously. We'll say female was raped. There's evidence of a rape. The person who perpetrated it, though, has some type of relationship with the prosecutor, and let's say you've got corruption in an area. Because of that, that prosecutor can quite literally make a decision not to prosecute that person, and that would be that sole prosecutor's discretion. Would that happen? In most cases, no. Does it happen? Can it happen? Yeah, those types of things can happen. It's a prosecutor's decision. At which point you move further into the trial process. Here it mentions the judge discretion, bail, if there's any acceptance of pleas, and depending on what system you're talking about, you could dismiss charges, and when you get through the process of the trial itself, you're talking about imposing sentences. If you've been convicted of something, you're on probation, you do something else, or somehow end up in front of a judge again, it'll be their decision as to whether or not you can continue through probation. If you had a suspended sentence, if that becomes reactivated, any number of things. Okay, so here's where we get to classification of crime. So grade of offense, felonies and misdemeanors. That is the most common classification of crimes. So you have that separation between felonies and misdemeanors, or serious and less serious crimes. Here it mentions moral turpitude. That's also built to some degree within in felonies and misdemeanors. So the things that are morally reprehensible are viewed more seriously, but may not be the same. For example, look at we'll go with something like child molestation. How many different grades of child molestation are there? How many different statutes are there for it? And what you'll see is that the more serious it is, the more it would violate moral sentiment. And because of both of those things, it's more heavily punished, and should be. Some even say, I would say, that they're not punished heavily enough. That's a different conversation. We'll get into that kind of stuff when we start getting the actual statutes and looking at penalties and that kind of stuff. We're gonna have some fun. Other classifications, infamous crimes and non-criminal behavior. So when it says non-criminal behavior, you mentioned juvenile acts. Really, what you're talking about there is more likely status offenses. So what that means is things that are not criminal that someone could be punished for, a juvenile could be punished for. That's more of a discussion of the juvenile justice system. We won't get too heavily into that. Limitations on criminal law. A typo in my thing. I have to fix that, but it's already posted, so I'm not going to. You'll see a typo on this slide. So void for vagueness is one of the big ones. So it gives out here the three characteristics. So if you make a change to law, you may notice that anytime there's a change to statutory law, there is a certain time period before it goes into effect. This is one of the reasons why. You have to give fair notice or warning to those who will be subject to those changes. And that applies to criminal law. It applies to a number of things. And that's why, if there's going to be a vote on something, there's such, a period of time that after it's approved before it's enacted. So we must guard against arbitrary and discriminatory enforcement. So basically you're talking about the 8th and 14th Amendments, that kind of thing. So you might also must not deny people their First Amendment rights, such as the right to freedom of speech. So I think I'll just leave that at that. Ex post facto laws, after the fact, is what you're talking about. So that would be holding someone culpable for behaviors that were only recently criminalized. So past behaviors, changing criminal law, and then going back and trying to hold that person accountable for those behaviors before they were criminal. Trying to think of a good example of that. We'll say a state has recently changed its definition of the term rape from forceful rape, where you had to have evidence of force, to non-consensual sex, sexual acts. Okay, so that's a big change. It's not to say that what happened before wasn't rape. It's just you couldn't go back and hold that person accountable to this new definition, because it wasn't the definition that was active at the time of that act. So it's one of those things that's a limitation. Bill of attainder. So that's any legislative act that inflicts punishment without judicial trial. So you can't do that. Statutes can be repealed or amended. Yeah, that's pretty straightforward. Cruel and unusual punishment. There we get the eighth amendment stuff. So void for vagueness is one thing. Here you start talking a little bit about some 14th Amendment stuff. Here's where we get to the 8th Amendment stuff, cruel and unusual punishment. So if it's a cruel and unusual punishment, that's something that can be a severe limitation on the penalties associated with the crime. A good example of that would be the death penalty for rape. So prior to the 1970s, well, into the 70s, the crime of rape could carry a death penalty. It's like, is that cruel and unusual? Which is kind of funny, because if you go and ask a class that, most people that they'd probably still be like, yeah, you should still be able to do that, which is fun. But the Supreme Court had, in terms of proportionality, it's disproportionate to the crime according to the Supreme Court. So that's the big thing is you want proportionality, the balance of the harm that was caused along with the punishment that is enforced. Here I mentioned torture and unnecessary pain are not permitted. There's a lot I can talk about on that. I won't go into much detail, but if you want to read on some of the history of the use of torture, well, I guess I should say, probably my favorite book related to it is Beccaria's on Crime and Punishment. Basically what it is it's from the 1700s, and it's a couple 100-page treatise against the use of torture, false imprisonment, that kind of stuff. It outlines. You can read it and see the framework for the country as we have it today, and realize that it was set out at about the same time this country was developing, but it was written over in Europe and has a pretty heavy history to its use and influence in the development of our country. Okay. Due process, equal protection. That's literally the 14th Amendment. So it mentions here it's associated with a very large body of cases. Yes. In fact, if you take in what was it, criminal evidence? Was it criminal evidence or procedures we talked about it? I don't know. I'm kind of drawing a blank on that. Basically, all your substantive rights were incorporated through the 14th Amendment, meaning the first case that dealt with them being used in trial, being used to protect a charged party at trial, were brought up as 14th Amendment cases. So it's like your right to a lawyer, your right to counsel. It's like you only have that right, you only get that right because someone didn't get that right and challenged it at court with a 14th Amendment case. So, there you go. Right to privacy. I got in there a Supreme Court case, Griswold versus Connecticut Kid, 1965. That's just gonna be aware of that. You don't necessarily need to know that for anything. But basically what you're talking about there is, and that will come up in later discussions, that everyone has a right to privacy. It's not specifically outlined within the Constitution or the Bill of Rights, but has been identified as falling under the penumbra of the First, Third, Fourth, Fifth, and Ninth Amendments. So basically falls into the shadow of those. Out of those, probably one of the bigger ones would be the Fourth Amendment, because that protects against unreasonable search and seizures. Okay. How we establish guilt. Here's where I got the burden of proof stuff. Our system is an adversarial system, which means that the two parties argue against one another. That's different from other systems, probably notably the inquisitorial system. Mainly in that, you know, the biggest thing there is the presumption, a presumption of innocence. In inquisitorial systems, it's more of a presumption of guilt. You have to prove that you're innocent. It's more difficult to prove something than it is to disprove something. You know, it's sort of like, look at it this way. You know, that presumption of innocence means that they have to prove that you're guilty, which means it gives more weight to keeping people out of the prison, out of the criminal justice system any further than what they already are. You have two basic errors is what I'm talking about. You can end up falsely imprisoning the innocent or letting the guilty free. Those are the two errors that happen within our system. Which one is the greater harm? Some people say letting that guilty person go free is the greater harm. Some people say that imprisoning the innocent is the greater harm. In terms of our society and its development, imprisoning the innocent was the greater harm, because that's been the historical harm that we've had to deal with, well, for centuries, is literally what you're talking about. How much you weight those things is important. Basically, what you start talking about here is that no matter how you weight those systems, you're still going to have both those errors that take place. Right? You know, no matter how much you weigh the system to make sure the guilty are condemned, you'll still have guilty people who go free. No matter how much you weigh the system to keep the innocent out, you'll still have some innocent people condemned. I mean, if you look at the death penalty, when we talk about that, it has automatic appeals. It has, you know, a person must go through so many appeals before they can even be executed. And most states aren't really too active in executing people. That being said, looking back at things like the Innocence Project, you can identify people where they were innocent. They went through all the appeals that they could, through all the proper processes, and still came to the wrong conclusion and resulted in death. And that's the one we watch most closely. You're going to have those errors no matter what. Another way to look at it would be, it's like, if you want to make sure that the guilty are condemned, there's a very easy way to do it, is to condemn as many people as you can, as much of the population as you can, because that's how you get the guilty. Because everyone's guilty of something. Then you're back to that presumption of guilt. You're back to that inquisitorial system. That presumption of innocence is why we favor the way that we do. And even then, like, if you want to have everyone innocent, if you want everyone to be free, the guilty will go free. It's like that's the problem with that. Not, you know, going to the extremes isn't a good example, isn't a good way for any system to act, but it's still, you know, a good way to kind of identify the families of the systems, as they will inevitably be. And we've already talked about burden of proof, so I'm going to skip over that. Okay. So here it says determining criminal culpability. Basically talking about if you're talking about bench trial, it's the judge that makes the determination as to whether a party's guilty. If you're talking about a jury trial, it's the jury. Depending on the state, it can be a little, criminal cases, you're talking about unanimity. I'd have to look at, I'm actually pretty new to this state. I haven't been here a year yet, so I need to sit down and go through the information on our system here. So you may any number of jurors, typically you're talking about 12, but it can be more or less. But we'll say 12, unanimous. If there are not unanimous, hung jury, it ends up in a mistrial. That's where there is not unanimity. On the other side of things, you have jury nullification. That's where all of the elements of a crime have been proven beyond a reasonable doubt, but the jury still decides to not enforce that law because that law may be unjust. That's one of those things that a lot of students aren't aware of, and if you walk out into the general population, they aren't aware of. Court system knows this, but they do not inform jurors of this because that's something that the jurors themselves need to be aware of. It's a very important thing because there are unjust laws that are on the books. There are times the law is used unjustly, that those with that discretionary power use it to their own benefit. This were an ethics class, I'd give you some examples, but if you guys want any examples of that, or me to talk about that stuff as we start getting specific statutes, I can let me know and see what I can do. With that is the end of the stuff I have for this chapter. I'll make another video here shortly for, I said chapter and section because it's not following the chapters. So this part is part 1, actually will be part 2. I think I've got it written out in the syllabus as different parts, but basically what will happen is once we get through some of the basic general stuff that you need to know, then we move into the specific statutes. So here we're going to talk, like we talked about, basic introduction to criminal law. The next will be elements of law. After that, I think we start getting into some of the defenses and justifications and that kind of stuff, and we roll off into the actual criminal statutes. And that's when we'll start really heavily getting into the textbook. The textbook is just criminal statutes. It's got some preface to it and some introduction. I wouldn't say chapters so much, but it'll have that information beforehand, and then we'll move into the actual statutes. While I'm talking about it in terms of the book, once I get a copy of it, which I'll have one tomorrow, basically what we'll do is I'll take a heavy look at it and make a determination as to whether or not it is in fact required. If we can get by on just using the Oklahoma legislative website, because that Oklahoma legislative website will hold all the same statutes and will be up to date as well, and will save you all $100 or more. So and whenever I send out the notice of class is open, I'll make sure to note that to everyone's like, hold off on the book. I'm still getting a copy of the book to make sure that it is required. So if it isn't required, we'll just use the websites and kind of build off of that. With that, if you all have any questions or need anything, I'm only ever an email away. You have my office phone number. I don't know how much I'll be in the office because it's basically empty. We got ready to move a few weeks ago, but that move got delayed a little bit. So we'll be moving probably within the next month to another building on campus. If you need me, email me. My cell phone's on there, but that's for emergency purposes only. Have a great day. See you in the next video. Bye.